Good morning to both of you.
Good morning, Your Honor.
Before we begin, let me just note that we have received a request to allow videotaping of these proceedings, and 2 cameras have been set up. We will allow that. The main consideration we have is that recording cannot disrupt or interfere with our proceedings. And if anybody else wishes, I saw someone here with a smartphone type of recording device. We'll permit that too, as long as it doesn't disrupt anything. So by that I mean, please don't hold it up so it blocks somebody else's view. And if there are any lights that shine on us that are disrupted, we'll have to ask that that be turned off. But with that understanding, and actually let me just make very clear for the record that what I just said are the findings of this court as far as allowing recording devices here. And with those limitations, the recording devices are appropriate. So with that, we will start the clock going and turn to Mr. Worthington.
Thank you, Your Honor. For the record, John Worthington, I'm the plaintiff in this action. The first time we went up with this case, the position of the defendant was that WESTNET was just a collaboration. It was not an agency. The briefing will bear that out. And the Supreme Court sent it back down to the trial court, and at that time I put thousands of exhibits in for the trial court to review, and a lot of these exhibits showed forms that showed that WESTNET had been placed in the form where it said agency. And there were a bunch of documents that I had showed the trial court during a particular hearing. And during that hearing, it was admitted that WESTNET was an agency. And it was clear from that particular point on that WESTNET was a drug enforcement agency, which also is verified by the interlocal agreement itself, which says that they're creating a drug enforcement agency. And you'll find that on CP 244. So there's a different set of facts now on the way back up. And unfortunately, the defendants argued that, well, we're an agency, but we're not a legal agency. And the Public Records Act says all agencies, so they can be legal, illegal, quasi, whatever they want to call, kind of agency they want to call themselves, they're subject to the Public Records Act.
Mr. Worthington, I'm going to interrupt you for a moment. I forgot to ask you whether you reserved any time for rebuttal.
I did, Your Honor.
And how much?
I reserved 10 minutes because I'm trying to make a quick case and get done so I can, most of what I feel is going to be argued outside the PRA. And
you answered my question, you go ahead.
Okay. And so basically, I didn't file Uniform Declaratory Judgment Act case. I didn't file a 1983 action. So the trial court at that point should have applied the PRA to the agency. Now, what they were able to do at that point was convince the court that, and this is the document that you see up there, is the document that, there were many of these documents that they were able to convince the court that it was under the Kitsap County umbrella. And in the trial court's defense, a trial affidavit when you got 1,000 exhibits is rough. And they might not be able to see everything that needed to be seen. And so when this document comes up and the defendants point to it as the proof that it's a Kitsap County process, this individual, Carlos Rodriguez, that signed it, is a Washington State patrolman. And so what this document really represents is a WESTNET agency action. It doesn't represent a Kitsap County action, even though it's signed by Steve Boyer. It's actually signed by a state patrolman, and the initials KC, they don't stand for Kitsap County, they stand for Kathy Chittenden. So the defendants were able to convince the court that WESTNET was under the Kitsap County umbrella. And that's impossible because Mason County are also part of WESTNET. The State Patrol is part of WESTNET. The City of Bremerton, Pierce County, part of WESTNET. There's just no way for them to be part of a Kitsap County umbrella. Now, moving on to, this is what the trial court ruled, is why they prevailed. The previous case, which this court ruled on and the Supreme Court just finished a ruling on, they convinced the trial court that that collaterally stopped me from bringing up some issues. But when we were before this court, twice they argued that the parties were different and the claims were different and that they had no bearing. So pretty much everything else is just smoke inside the coffee house, and we are done. I mean, nothing left to do except go back to the trial court and apply the PRA to the agency WESTNET. And I'll take questions that you have, but really at this point, I don't know how else to continue on because just that's what the trial court ruled on at this point.
Very good, thank you. You have your rebuttal time remaining.
Good morning. May it please the court. I'm Ione George, Chief Deputy Prosecuting Attorney from Kitsap County. Well, it's a bad way to start, excuse me like that. I would initially note that one of the problems or one of the obstacles I have in responding is determining how to begin a response. Many of the arguments made and set forth by Mr. Worthington, particularly in his briefing, are set forth without a proper referral to the record and what they're based on, or the referrals to the record are frequently based on incorrect rough citations to the record. So I'm faced in large part with responding to something that isn't a concrete point in the record or something that actually is a concrete thing in the record. I attempted in responding to the arguments to concisely set forth what happened below and identify for the court what the actual rulings of the court below were, what the actual issues presented to the court were, and what happened below. I can take my 15 minutes now and run through that and reiterate what I argued below, but this court asked for oral argument, and I think my time might be better served in asking this court, do you have questions of me, and are there things I can specifically respond to? One thing I would like to start with, though, is the item that Mr. Worthington put forth and my statements that it is an agency. As I indicated in my brief, that was not a concession on behalf of my client WESTNET, that WESTNET is an agency per the statutory reference to the Public Records Act and what is an agency under state law. That is, again, taken out of context. Mr. Worthington, at that specific hearing, kept saying that the position of WESTNET was that it does not exist, it does not exist. And after many years of contentious litigation, I was responding, of course it exists. It is a collaborative drug task force. It exists. It is an agency, is what I said, somewhat in frustration. It exists. It is a drug task force. They go out and they investigate crimes. It is a collaborative entity of individuals from different agencies that go together and investigate crime. It was not an admission that it is a state agency under the Public Records Act. That quote was taken out of context. It was not a concession on my behalf. It was that it's an agency that exists as a legal entity subject to suit, which was the very legal position that I have been challenging on behalf of my client for the last 10 years. It was not a concession in court. That being said, are there questions this board has of me that I can answer that have come up as we review these meetings?
I expect we will have questions as you go in with your argument, so.
Thank you, Your Honor. Then essentially, as was argued below and what we were presented with when we came back from rebound from the Supreme Court, the question that was asked by the Supreme Court was to conduct a discovery and determine, is WESTNET, the Drug Task Force Collaborative, acting in accordance with its non-legal status? Is it is it an entity acting without legal status as it was set forth in the interlocal agreement? Discovery was promulgated, and we argued to the trial court, and the trial court agreed that WESTNET was acting in accordance with that interlocal agreement. They are not acting as an independent legal entity. All of the individuals working with the Drug Task Force were employed by their independent employers. All of the organizations, the different sheriff's departments, the different cities who had contributed employees to work with the Drug Task Force were employees of the independent agencies. They were working as employees of those agencies, coming together and working under the resources of those agencies. The second, WESTNET had owned no property, at least no property. It created no documents of its own. The investigative reports were kept and maintained as Sheriff's Office investigations, and when records were requested of the investigations, they were released as Sheriff's Office investigations.
Is the
I'm sorry.
interlocal agreement part of our record?
Yes.
And do you know the court's paper number on that?
I don't, but I can certainly supplement and advise that of the
Okay,
board.
so does that interlocal establish a board for administering WESTNET?
It has a policy board, yes. And one of the things, as an aside, one of the things that the interlocal addresses is a fund for seizure property. It was contemplated that that the group would investigate drug offenses, that it would seize, that these investigations would have seizure of property, and that it would set up a seizure fund that would be maintained by, it says it would be set up in the Kitsap County Treasurer's Office, I believe, but it sets up a fund that we set up in Kitsap County where forfeiture funds would go and be maintained. And in fact, the interlocal statute, or so if I don't have it off the tip of my tongue, talks about interlocal when an interlocal agreement sets up an organization such as this that is not a legal entity, there are particular things that have to be done, such as a policy board that is set up in this interlocal that is required if it's not a freestanding legal entity. So yes, the policy board is one of those things that has to happen, and there is one set up. And the fund that Mr. Worthington takes issue with is one of those things. And
Well, there are essentially two types of interlocal agreements, aren't there?
Yes.
One which is simply a cooperative agreement among agencies, entities, and the other one involves creating a third entity.
correct.
Which of those does this fall under? Does
This is
WESTNET?
the non-legal entity. So we're just a collaboration between the organizations. And so Kitsap County has taken the lead on everything, which is why when you see WESTNET, they come up with a logo, but it's got Sheriff's Office all over it, which is why everything says Kitsap County Sheriff's Office on it, and Kitsap County Sheriff is the signature on the bottom of all things. And different organizations take a lead role at different times, taking the onus of some of the work, but it's always been the Sheriff's Office lead, which
Now,
is
the
why...
policy board you talked about, is that, if there is any governing entity for WESTNET, is that the entity that makes decisions for WESTNET?
Not really. Well, they get together, they discuss what's going on. I guess in a sense, we really haven't gotten into the logistics of it. In a sense, they just talk about what they're going to do. I think they might talk about next year's plans. I don't know. We really haven't gotten into that sense.
What I'm driving at, obviously, is if, depending on what this board does, couldn't it indicate or signal that WESTNET is a separate entity and should be deemed as such? At least under the interlocal.
what the Supreme Court said was to look at the actions of WESTNET and see what they're doing, and is their function that of an independent agency. And so the discovery that was promulgated looked at the functioning of WESTNET and are they acting as an independent agency. And so the discovery looked at what contractual agreements are there, what property agreements are there, where are they operating out of. And although the physical location of WESTNET was not divulged because it can impinge upon their investigations, what was released was the lease agreement for the facility that they're at, and it's leased by the sheriff's office. The employees that work out of WESTNET are employed independently by the agencies who are contributing. The copy machine that they use is leased by the sheriff's office. Their postage is paid by the sheriff's office. Anything they do is paid for by an independent agency, not by them. It's effectively that if they do anything, the liability of what they do is taken on by the individual member who incurred that liability, which is how I ended up here. Because this is all about a public records request that Mr. Worthington served on the sheriff's office that he took issue with. He sued the sheriff's office, but he'd signed a settlement agreement with them, so that lawsuit was dismissed. He then reinitiated a lawsuit for the same public records request against WESTNET. Because the substance of that public records request, as part of his complaint here, is about a public records request that he served against the sheriff's office for a sheriff's office record, but he couldn't sue the sheriff's office, so he sued WESTNET instead. But the sheriff's office, or WESTNET, if this suit went forward and any liability was incurred, it was incurred because of sheriff's office actions. That's why I'm here.
If we follow your approach, are we arguably setting a bad precedent under the Public Records Act by creating a situation where the individual who wants the records has to figure out a bureaucratic warrant as to who he or she should direct this at, which in some situations could be difficult.
Which is exactly what the Supreme Court said. Look at what's going on. The Supreme Court said, would we be frustrating the Public Records Act if WESTNET is not a legal entity? So we look at it. Mr. Worthing, the question was, would he be frustrated in this if WESTNET doesn't have to do this? Mr. Worthington has proved that we're not. He served the public records request, and if you go through the litany of records he has filed, each and every public records request he has submitted has immediately been responded to by the sheriff's office. Everyone he served has been responded to by the sheriff's office. The sheriff's office has the public records, has complied with the public records requirements in every regard. If he serves a public records request for a WESTNET record, which he has, it is immediately responded to by the sheriff's office. If he asks for a WESTNET record, it is responded to by the sheriff's office. If he sends it to any one of the outlying, any of the outlying agencies who are involved with it, it's going to go to the sheriff's office and get responded to by the sheriff's office. And in light of this litigation, the WESTNET interlocal has been amended to identify this as well. We're responding. We're aware of the issues. But the point being, no, the records in this case clearly indicate that he has not been frustrated by this, and in the future it will not be frustrated by this. And that is a specific question answered by the trial court below. It was the question asked by the Supreme Court and the question answered by our trial court. Would the Public Records Act be frustrated by a determination that it is not a legal entity? And the trial court responded no.
Is Mason County one of the participants?
I believe they were originally, and I think they are participating.
If a citizen had sent the public records request to Mason County, what does the record show would have happened?
It would be sent to the sheriff's office. If Mason County was involved in a WESTNET investigation, it would be responded to by the Kitsap County Sheriff's Office. So those were the two questions asked by the Supreme Court, and that's how the trial court responded. The discovery was promulgated. The trial court looked at the information. We submitted the summary judgment motion based on the information that the discovery brought to light. That's what the Supreme Court asked. The trial court reviewed it, the trial court answered those questions and said, in response to the Supreme Court, the questions have been answered, and the trial court's response was the same as it was before. Then,
So I'm confused
Yes,
though,
sir.
just like logistically. If somebody sends a public record request to WESTNET, does somebody at WESTNET respond and say, we don't have the records, or is it forwarded to the sheriff automatically?
WESTNET isn't an entity.
I understand that, you're not answering the question.
It's going to go to the sheriff's office.
Okay, so even if it's addressed to WESTNET, the sheriff will respond to it, so it's not somebody rejecting it from WESTNET?
Correct,
Okay.
correct. Because the mail to WESTNET is the mail to the sheriff's office. The next confusing thing really that happened was, well then, Mr. Worthington filed for summary judgment. Those motions were denied because Mr. Worthington's complaint was with regard to a public records request. And his complaint was for what he set forth, what he believed to be an improper response to a public records request. But his summary judgment motion was for summary judgment for what appeared to be declaratory judgment actions. He asked for summary judgment with penalties for actions that had taken place years before the filing of his summary judgment complaint. And essentially what the trial court ruled was that he was seeking summary judgment for actions that were not part of his filed complaint. And so summary judgment was properly denied in those regard. Frankly, it was that his summary judgment motion didn't match what his complaint had been filed for. So summary judgment was properly denied in that regard. His next motions had to do below with motions to strike all the pleadings that had been filed on behalf of WESTNET. It was the same motion that he filed before this court that this court denied. And we have a couple seconds. If you don't have any questions, I'm going to sit down. Thank you much. Everything else I have to say has been set forth in my briefing.
Thank you, Counsel. Josh, how much time does Mr. Williamson have left?
9 minutes and 10 seconds.
Very good.
I just want to make a point that when you're a non-legal entity and you're getting checks written to you and you get them cashed as WESTNET, hard to keep a straight face when you're arguing that you're not a legal entity. If you're not a legal entity, then you're an illegal entity, and either one is covered under the Public Records Act. On May 23rd of 2011, I made a request straight to WESTNET, and that was sent off to the Kitsap County Sheriff's Office. The statements that the records are stored and kept at the Kitsap County Sheriff's Office are a false statement. The records are kept at a secret location at a headquarters under the command and control of the Washington State Patrol. They agreed to be under the command and control of the Washington State Patrol, and they are now, as it was used against me, they are borrowed servants, that's what they were determined to be in the federal case. Loaned employees and borrowed servants based on a contract. Now they convinced the trial court that everything was right there at 614 Division Street, and that just wasn't the case. If Kurt Russell was in the audience, he said, "Why don't you see for yourself, Judge? We could have walked for days at 614 Division Street. We wouldn't have found a record because it was held at the headquarters." The only thing the Kitsap County Sheriff's Office does is apply the redactions. Now, both the State Patrol and the JAG contract, which is the Kitsap County, all their records are kept at the headquarters. And they're all faxed no matter who needs them. Now, if you look at CP 33, you'll get an indication of who's calling the shots when it comes to requesting the record. And the State Patrol has a special procedure for the NCIS records, which, quite frankly, Kitsap County didn't really have. Now, I've gotten records from the State Patrol. I've gotten records from the City of Bremerton. And the fundamental problem with the interlocal agreement is it has no third-party agreement that allows Kitsap County to distribute the records of Mason County, the State Patrol, the City of Bremerton, and on down the line. So again, looking at the Supreme Court and what they said, the operational structure, which wasn't available to you on the first time up, is now available to you. You can see them calling it a headquarters. You can see the Washington State Patrol participation grant and the signatures by Kitsap County agreeing to be under the command and control of the State Patrol. And so, and these other cases, well, quite frankly, if WESTNET doesn't appear in the Pierce County case, and I just continue that case, but they appeared. And they didn't want to intervene as Kitsap County and defend this Kitsap County records process. They filed a notice of appearance as WESTNET. I believe they did that because they would have waived the settlement agreement, which at that point they'd already been running around trying to stop my pursuit of the truth. So, and under the RCW, on the table back there is JS printouts back to 1998 of WESTNET activity. The courts have known that WESTNET exists because each member entity has its own seizure forfeiture process. And they're enforcing a state statute, so they got to give a cut to the state. So when they get into WESTNET, they have no way to keep track of that seizure forfeiture process, so they did it as WESTNET. They might have intended not to create a legal entity in the interlocal agreement, but once they set up the seizure forfeiture process, once they started setting up the fines and fees process, then they start leaving a trail of checks written to WESTNET back to 1998. So this notion that they don't legally exist, sure, they want to give it all back now that they've taken it. And if you're not a legal entity, then what are you? An illegal entity? So this is where the sanctions should have come in. While the Kitsap County Sheriff's Office is arguing to the court that they don't legally exist, they're drawing up their own court motions asking for money for WESTNET, fines and fees paid to WESTNET. That's where these checks come. These particular checks are from Mason County. So you got Pierce County, Mason County, sending checks not to Kitsap County, not as Kitsap County, not to any member entity. You're sending checks to WESTNET. So under the RCW, I think it was 2.08, where I'm speaking just for Kitsap County Superior Court, when one judge makes a ruling that, oh, okay, WESTNET, you're going to get $1,000 in fines, then that means Judge Laurie, the first judge, who probably signed one of these herself, was bound by that decision to make them a legal entity. Because when one Superior Court judge makes a ruling, all the other Superior Court judges are bound by it. So unfortunately, their seizure forfeiture trail goes too far back, and the JIS, it's frustrating as a citizen when you're coming to the court and you're hearing this argument that they don't legally exist, while the very court you're in front of, or the court system, is collecting money for the entity they say doesn't exist. So to me, it's deference. We're this far because of deference. I couldn't get a ruling on whether or not they were agency the first time because they said they weren't. They were just a collaboration, and so here we are now up again, coming up. And so now they're an agency, but not a legal one. So, and then they're saying that they're Kitsap County records, but they're not intervening as Kitsap County. And they can't bind the other parties. That's in the interlocal agreement. They want to, I have the interlocal agreement. If you want me to put it up here for you, I don't know if I got enough time, but in the interlocal agreement it says that they can't bind them. I got it right here. They can't bind the other parties. So, as much as they want to step up and represent all of WESTNET, they can't. They can only represent Kitsap County, so they should have intervened as Kitsap County. But they didn't, because they had a settlement agreement. They were intent on disrupting my public records request all the way back to the Pierce County case. And that's what they did. And they were able to use this, fill the coffee house full of smoke, and turn this into, from a Public Records Act case, into some other kind of case where all of a sudden now we're going to decide whether or not they're a legal agency or a legal entity. So I think it's unethical what they did, and I believe they did it because they had a federal case and they were trying to keep the wheels on a phony DEA raid. And I never settled for what Kitsap County did because Kitsap County said they weren't there. So the reason I didn't file on Pierce County, when in Pierce County case, the reason I didn't file on Kitsap County is because they said they weren't there. Only people I could prove that were there was the State Patrol, Paulsbo, City of Bremerton, so that's who I filed on. Now later, I found out only from the DEA that they weren't involved in the case. So then at that point, okay, the Kitsap County settlement was based on a DEA raid and a minimal involvement. I never settled for what Greg Dobbins, a Kitsap County employee, did because I didn't know he was involved. So this is what's really happening. And now you're in this position where you've argued that in front of a court that you don't legally exist. You got a trail, I hate to use the word, a RICO Act trail, of financial activity while you're telling the court you don't legally exist. You're collecting money in the name of an entity you've told 3 courts doesn't exist legally. So how do you want to have it? Do you want to have them be agency on the Public Records Act? Or in the other follow-up case that's coming up that the judge transferred to King County because she'd seen enough finally. I mean, at first when I hit her with 1,000 pages, she didn't know what to think. She couldn't sort it all. But then she started to look more and more at these documents and she realized, well, we're collecting money for WESTNET. I got a conflict of interest, so I'm going to approve your motion for a change of venue. So they might not have intended to be a legal entity, but they had to be because they couldn't keep track. And then by virtue of the evidence, they went into the administrative process and does WESTNET have a motion? Yes, WESTNET has a motion. And that's in the motion to reconsider. I had a transcript made of the hearings, and it's just, does WESTNET have a motion? Yes, WESTNET is moving for there to be a default order. At that point, it's not a scrivener's error, it's fraud.
I have let you go over your time a little bit, so if you would take a couple seconds to summarize if you'd like.
It's time for this case to be over. We've gone at it for so long now. I did a very thorough brief. All the arguments there. Don't set Mason County and the State Patrol and all these other agencies who don't share this position up for a problem. Thank you.
Thank you. Thank you both. With that, we're done with our cases. We are having oral argument on this morning. We are now going to go conference these cases.